of states applying for this Article 5 conventions, but we've never been able to get there because the states have never agreed or aligned on the subject matter. In order for this convention to happen, it requires, as I said, those 34 states to aggregate. That aggregation requires that the applications are identical or substantially similar in nature in order to get the convention. Now, states can instruct their respective delegates to entertain a more narrow scope than what is within the aggregated application, but they cannot broaden the topic beyond the identified in the 34 past applications. Another thing I hear from the opposition, many delegates will not be bound by the states when they get there. They believe these delegates will have fuller powers. And I would say in the context of the Constitution, and if you read Article 5, their power is drawn specifically from Article 5 of the Constitution, and is thus inherently limited. The language of Article 5 specifically indicates that they cannot draft a new Constitution in total. It states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution. Note the language, as part of this Constitution, not a new Constitution in total, or anything like that. And after whatever comes out of the convention has to be approved by 3/4 of the state. So anyone to say we're going to get a new Constitution out of this process is, you're saying that the convention would magically exceed what they are bound to in the first place, and then 3/4 of the states would want to get rid of the Constitution after the fact. Article 5 says Congress calls the convention. Congress can't take over the convention of states. Congress's role is limited to the call, which says the date, time, and locations. Legal terms refer to as ministerial secretarial role. In this role, Congress has acted in a limited administrative capacity. I've heard in several, I guess I would say just the opposition claims that Congress would perhaps use Article 1 powers that under the Constitution could simply take over the Convention of States once it's called and do as they will with our Constitution. But that's not true. The question has already been decided in federal court. Idaho versus Freeman, 1981, the court found that, quote, in proposing or acting on a proposed constitutional amendment, Congress is not acting pursuant to its ordinary legislative powers found in Article 1, but acts according to those powers granted under Article 5. Thus, Congress, outside of the authority granted by Article 5, has no power to act with regard to an amendment, i.e. it does not retain any of its traditional authority vested in it by Article 1. I've heard the opposition point out a Congressional Research Service report found that Congress has previously proposed broad responsibilities for itself regarding the Article 5 Convention. What they do not tell you is that every single one of those proposals were defeated, not even brought up by a debate in Congress. Even Congress knew it didn't have the authority to take over a convention of states. This very same Congressional Research Survey, cited by the opposition earlier, has this to say in conclusion about a runaway convention. Finally, the report noted that the founders did not provide unchecked power to Article 5 Convention. Every amendment proposed would be subject to the same conditions faced by amendments proposed by Congress. The notion of a runaway convention succeeding in amending the Constitution in a manner opposed by the American people is not merely remote, it is impossible. My final point, the Article 5 procedural will not threaten the Constitution. We want to use the Constitution to restore the Constitution. My question to you, for those that say that, is which Constitution are you talking about? Are you talking about this pocket Constitution that we like to carry around? Are you talking about this?
Nope.
Point of order.
Representative Love, for what purpose?
Point of order.
To make it
I will ask volunteering to do use of props in the way.
Just to be clear, the Constitution is a problem.
But you're using it as a the prop.
All right, we'll vote for this resolution so that we can make this look a lot more like this.
Representative McCollum, to Representative Love's point, you are allowed to bring a book to the well, but you may not use a book as a prop. And at this point, Representative McCollum just brought a book to the well, so it is permitted.
Thank you.
Okay.
Representative McCollum?